Hello there.
Hey, how are you? How you doing, sir? Hey, good. How are you?
Waiting on train, Greg. Or do you wanna go ahead and start? You wanna get down? It's up to you, 'cause it's not, hurry.
Are they not supposed to be in the hearing?
They are, but.
Morning, Your Honor. My apologies. I was just making some copies for the
Oh, no worries.
respondent. I did not anticipate that he would be here.
Is the town ready to proceed?
Yes, sir.
All right. Hereby call this meeting into order. This is the code enforcement for the town of Gulfstream. Cases, well, there's only one case, so it's going to be, the one case is going to be heard. It's a quasi judicial hearing, which means the formal rules of evidence do not apply here. However, all testimony is taken under oath under penalty of perjury. So if anyone is going to testify or thinks they might testify, there's a possibility they might testify. Would they please rise and raise their right hand and be sworn in? Do you swear or affirm the testimony you're about to give will be truthful and accurate under penalty of perjury on the laws of the state of Florida? All right. Please be seated. Floor is yours.
Thank you, Your Honor. Trey Nazaro, Assistant Town Attorney with the Town of Gulfstream. So first up is case number C-2301, fine assessment hearing. This is pursuant to your order. I'm going to go ahead and hand the materials that I provided you to the respondent, property owner who is in attendance. I had a lengthy conversation with his attorney yesterday to try to get to some sort of an agreement. I won't necessarily get into that now, but just going through the file, according to section 270 conduct of hearings, your order is to be provided to the violator within 10 working days after the hearing. We have an email from myself to the property owner attaching the order dated September 5th. So that has notice of the hearing and the violations has been provided. Within that order, you ordered that the property be brought into compliance by obtaining a permit to repair the roof within 14 days and compliance with fixing that roof be done within 14 days of permit issuance. There was a representative from Mr. Shaw who was under oath who indicated that that was sufficient time based on what the town had requested. I have a screenshot from the town's permit clerk indicating that the permit was issued on the 31st of August. And then if I could just get Mr. Dunham, are you familiar with the town's agreement with the town of Highland Beach for permitting?
Yes, sir.
And it is your understanding, based on communications with staff, that this permit was issued on the date indicated in that screenshot that's been provided for the record?
Yes.
All right, thank you. And then if you could just flip to the next page. This picture was taken by town staff on September 15th, which is the date that would have been required from compliance. Sorry, get you mic'd up. So is that the condition of the roof on the date in question?
Yes, sir.
What, if anything, has changed about the condition of the roof, just looking at the principal building first?
It appears it's been pressure cleaned, but the roof damage has not been fixed. It's not been completed.
Okay, and then going to the next photo, same question. Has anything changed regarding that roof as well?
The roof has been pressure cleaned, but the other damaged areas have not been corrected.
So is it your opinion that the violation continues to exist for both structures?
Yes, sir.
All right, so following that, we have just a simple calendar printout that indicates the permit was issued on the 31st. The 14 days of compliance pursuant to the order was September 14th. Violation day number 1 was 15. So the town is asking for a $200 per day violation for the principal building and a $200 per day violation for the accessory building, starting September 15th and running through compliance. There's been some indication that the property owner may pardon the construction.
Seems like a lot of buildings are under construction these days, huh?
That the property owner may remedy the violation by filing for a demolition permit. That process, it's my understanding, has been started. There hasn't been a permit issued, but that is something that they're entertaining. So I believe the violation will be cured soon, but we just like to request that the fine start as of September the 15th and run through the eventual compliance date.
Is the demolition for both structures?
I guess the property owner is indicating that yes, they intend to demolish both structures, which would take this, which would comply with your order.
That it would. Is there someone here on behalf of the respondent that'd like to speak? I'm sorry, I sort of jumped the gun there. Is there anything further that you wanted to present?
Mr. Dunham, you have anything else to add?
No, sir.
All right, no, nothing further from the town.
All right, I'll hear from the respondent. Please do.
So thank you, Your Honor, Mr. Magistrate. I'm not sure how to address you.
Magistrate is fine.
I'm sorry?
Magistrate is fine.
Magistrate, okay. Pleasure to meet you, sir. So I appreciate the time you're taking today in reviewing this matter. While I'm not
Sir, can you tell me your name, please?
I'm sorry. My name is Bhavin, B-H-A-V-I-N, last name Shah. I'm the owner of the property in question.
Okay, thank you, sir.
I'm not arguing with Manager Dunham's assessment of the roof of the property, but I would like to bring some important context into the play that might be helpful in you arriving at whatever decision you'd like to arrive to today. So number one, we met with you, and unfortunately, I apologize for not being at the last hearing. I only heard about this, the time frame of it the night before, and I was out of the state. But I appreciate you taking the time to hear from my contractor during that visit. We met that day. You essentially stipulated certain things needed to be done. We accepted those stipulations. Literally the day after we met you, the day after, we got hit with 3 more violations on the property. And these 3 violations came accompanied with messaging from the city that basically suggested we should demolish the building. So now on one hand, we have the desire of the city, of the town, and us to demolish the building, while at the same time, we are being asked to spend tens of thousands of dollars to fix a building and a roof that eventually is going to be demolished. At the same time, Mr. Magistrate, we are under a purchase contract to sell the property to a third party. And as you're probably aware, the contract does not allow us to do certain things to the property without the approval of the buyer side of the party. The buyer has already started spending tens, if not hundreds of thousands of dollars in constructing architectural drawings, engineering drawings, and we intend to come present those to the city on the 13th if the commission meeting is held here. But long story short, we did spend almost north of $27,000 in the 2 weeks that we had since the time you passed your hearing to fix the other issues that were violations of the property that are going to be moot for the most part when we demolish the property. We also spent a ton of time, as you can see, from power washing the roof. And I sent a message to both the manager and the assistant attorney, town attorney, expressing to them that the roof tiles that are made for this roof are no longer made in that same size. So after the roof contractor got up there, cleaned everything and saw the damage, they essentially suggested that we needed to replace the whole roof. And we can provide that assessment to you if you guys would like from the roof contractor. They don't make that same size shingle anymore. And that's why my contractor is here to affirm that. So the only option would have been for us to fix the whole roof, which would be almost a $200,000 to $300,000 expense. And at the time, after being hit with 3 additional violations, and the demolition of the property is essentially what we're trying to achieve, which is beneficial hopefully for the city and for us. We just wanted to have the adequacy of time to go demolish the property. With respect to the demolition process, my contractor is here to also support any testimony you would like to hear. We started the process almost 3 weeks ago for the demolition. I'm not sure if you're aware of the lengthy requirements to even file a demolition permit that exist in the town of Highland Beach, but we have to, for example, get FPL to give us a letter that says they're going to cut off the power. We have to bring in air conditioning contractors to make sure everything's done properly with respect to the HVAC units. We have to make sure that we figure out what to do with the septic tanks and have to get a report from a third party to assess that. We have to get the right fencing so that there's no issue with respect to debris. We have to make sure that the right water drainage systems and the water spraying is done on time. This is not something that can happen in 2 or 3 days. We submitted the final information for the permit to the town of Highland Beach last Friday. We actually included a survey with a surveyor's signature. We got a call from them saying that wasn't acceptable because they wanted a digital picture of the survey with the blue line around it. I'm not sure what specifically that means, but we got that yesterday from Mike Abram, who's a surveyor, and we passed it on to Highland Beach, and it's being entered into the system hopefully as we speak. So while I'm not here to argue the condition of the roof at all, or to be contentious with the town of Gulfstream, what I do want you to consider is we're doing everything within our power and what legally is afforded to us because we're under purchase contract to try to amend the situation as best we can. So number one, the idea of penalties being assessed and accruing while 3 more violations have been thrown our way that essentially suggest we should be demolishing the property almost seems like it's you know, a double hit against us, number one. And number two, if we demolish everything, which we have agreed to do, subject to the permit being approved, then we are ready to move forward. We just ask that there are certain things we need to present to the commission on the October 13th hearing, after which we would begin the demolition process, assuming we're successful in getting the permit. The second thing I'd ask you to consider is with respect to the gravity of the fines. I agree with Mr. Nazaro that there's 2 structures on the property, but the way I always understood it, and maybe it's my layman's view of the law, maybe I'm wrong, is that even if there's 2 structures on one address, so if you had a garage that was not attached to your house, would that be 2 violations or would that be 1? I was under the impression that that would be 1 violation, so 1 penalty would be accruing as opposed to 2. So that's my humble commentary on the situation. Certainly, I'm not here to argue these pictures at all. I'm here to just provide you the appropriate context that would allow you to make the right decision. Any questions?
Does the village, I'm sorry, does the town have any questions for the?
I mean, I have a question. Did Mr. Shaw
Based on,
I need you to use the microphone first.
I'm sorry, here. You want to use it?
hey, he's always in
We
charge.
got lots of them here.
All right. Mr. Shaw, just given your understanding of the demolition permit, how soon do you think you could get the demolition permit applied for? And then what's the timeline for demolition of the structure?
Sure. So my contractor is here to give you specifics, but I believe from what he told me this morning that the expediter has submitted the digital survey with the blue line around it as of yesterday. We hope to get the permit in process, and they've given us a tentative permit number, but it's not on file yet. So we hope that it'll be done today. That's the best information I have from the town of Highland Beach. Certainly happy to let you know as soon as we hear.
Great.
In terms of your second part of the question, which is how quickly we intend to demolish it, as you know, we're under purchase contract to sell the property, so I can't demolish it while I'm under contract unless I have the approval. And unless we find a way, which I believe there is now, based on your conversation with my attorney, to transfer that permit over to the new buyer to demolish it is very clear, both based on my understanding with the new purchaser as well as the substantial amount of time, which I thank you for, that you've spent with the prospective buyer, that they intend to demolish the building and build a one-floor home. So there's no question in my mind that the building is going to be demolished. But Mr. Magistrate, the issue that we're trying to solve for is today there's an easement, a 65-year-old easement or 60-year-old easement on the property that essentially, if I demolish the property today, nobody has to approve any kind of building on the property. So imagine from a buyer's point of view or from an owner's standpoint, if I demolished everything without the removal of that abandoned easement, how would that property be worth anything to anybody in the future, including me, the existing owner? So while if I improve the building today, even if it costs me dramatically more, at least that building would be grandfathered in. So my issue that we're trying to get to some level of understanding with the city on is we're agreeing to demolish, no question at all. But if we demolish, can we please remove the easement subject to the city's approval of the engineering drawings that we're ready to present to them in terms of how things would be maneuvered around the city water pipe, which we've already spent $100,000 of our own money moving so that the city has a brand new water pipe that they can tap into instead of a 50-year-old pipe that they're using today. So to Mr. Nazzaro's question, we intend, unless any.
Is that why you need to come to the town meeting on the 14th?
We were advised by the town attorney, Mr. Nazzaro, that we need to present that engineering plan as well as the architectural plan, as well as the buyer's intention in front of the commission so that the commission could either approve it or not, or ask questions, upon which we would be able to do whatever we need to do. If the result of that commission hearing is, and please correct me if I'm wrong, gentlemen, if the decision in that committee meeting or commission meeting is that, yes, subject to this, and this happening, we remove the easement, then we will 100% begin the demolition of the edifice.
Mr. Magistrate, Trey from the town, there are a lot of issues with the property, and I think that's why the property owner is hesitant to demolish the structure or agree to demolish the structure, which is what I'm hearing, given the potential sale and some other issues. It is true that the property is encumbered completely and totally 100% by an existing utility easement, and that the town maybe 2 years ago met with this property owner and talked about this concept of rerouting the water line and freeing up a substantial part of the property. Again, that was 2 years ago or more. So we're ready to move forward with some action that brings this property into compliance. I didn't hear anything from.
Well, I mean, factually where we are right now is I don't think there's any factual dispute that the property is in violation, that the roof is in disrepair, and that it can be, and I think both sides are in agreement, it can be corrected one of two ways. Either the roof can be repaired or the building can be demolished. I think that's the set of facts as we all understand them, right?
Yes.
Yes.
All right. So the dispute before me today is that the town would like to move forward with a fine for non-compliance with my original order, which gave us a date, which I guess was the 15th for the roof to be repaired.
Based, yes, sir.
Yeah. And your argument to me is that you don't feel as if I should fine you because you're making efforts to bring it to resolution, even though you haven't been able to do so. Is that essentially where we are here today?
Well, there's two parts to that, Mr. Magistrate. One is, yes, you're correct, because in the process of that, of being asked to fix the roof per your order, we were essentially hit with additional violations that leave us no option.
I'm not addressing those today.
Okay. All right, fine, but I'm just trying to provide context, because if I'm told to demolish the property or I have to demolish the property, it doesn't make sense for me to continue to spend money on a property I'm going to demolish, number one. And number two, I'd ask you to
Well,
consider.
I don't think that I mean, the town can correct me if I'm wrong here, but I don't think the town could direct somebody to demolish a building. They can direct you to bring it to code,
Correct.
but they can't direct you to demolish it.
Okay,
Unless, I guess conceivably there could be a situation where it's impossible to bring a building to code, and I guess they could
well,
point that out. But
I-
I haven't seen very many of those cases, but I'm presuming what you're saying is that the cost to bring this building to code versus just demolish it and build a new one doesn't make a lot of sense, right? Essentially. Yeah.
That's probably accurate. However, I can share with you emails I've received on behalf of the town suggesting that I demolish the property.
All right, putting that aside for a second. So you're asking me not to assess the fine or assess a reduced fine because you believe you're making efforts to bring this into compliance?
Well, my two arguments to you, sir, are, number one, I would not like a fine to be assessed. However, if a fine were assessed, then I'd like you to consider the fact that it's one property address as opposed to two different, a garage and a house.
Yeah, that is a fair question. Let me ask
getting violations.
the village to respond to that particular argument. The question about whether or not, because as I listened to you, you're suggesting that I should issue two separate fines for the two buildings on the property, and the property owner is suggesting that this is a single violation. How would you respond to that?
So there are two separate structures that are very significant in size and in violation. So if one structure was brought into compliance and the other was not, there would be a violation that was continuing. If only one of the structures was out of compliance with the code, then that would be a violation on its own. So the fact that we have two structures that are very distinct, very large and looming, and in significant disrepair, I think it's reasonable, and based on your order finding two violations, one for the principal and one for the accessory, to assess a fine for each individual structure.
Back and look at my order and see how I phrase this. Because I'm not sure that it was noticed as two separate violations, was it?
I'm sorry. With all due respect, sir, if I have two different buildings on the property, to Mr. Nazzaro's argument, and if I only fixed one and not the other, I'm still perfectly, I'm not arguing the fact that I should still be assessed a violation for the property until the full problem is fixed. I just didn't think.
Well, I would agree with that. I mean, fundamentally,
So, I mean, the town is willing to, if you're going to find a violation in the spirit of working with the property owner, the town is willing to stipulate that there's only one violation on the property, and the fine of $200 per day be appropriate.
I appreciate that, Mr. Nazzaro.
So I will tell you, typically in situations like this, my inclination is to assess the fine as a going concern, because I've been doing this a long time, and one of the truths of the matter is that once people leave the room where these things in, if there isn't an impediment to get things done, often they do not. I'm not saying that's true of you. I'm just saying that is fairly typical. There is a process by which one can come for a reduction of fine once one is in compliance, but at this point, the following things are definitely true, which is that there's a violation on the property and that violation has not been remedied in the time permitted under the order. So the appropriate thing for me to do in this case is to issue the fine. I do agree with both you and the town attorney that this constitutes one fine, and that to bring this property into compliance, you're going to need to address the concerns on both buildings.
So may I ask a question, sir?
Mm-hmm.
So, and I don't know if this is to you or to the town attorney. So forgive me if I'm asking the wrong person, but I just want to confirm that once we do get a demolition permit issued from the city of Highland Beach on behalf of the town of Gulfstream, would the fine stop accruing?
My understanding, according to the underlying order, is that the fine will stop accruing when the property is in compliance. And compliance would be that the roof is either repaired or removed pursuant to the demolition permit. So the fine would accrue until one of those two conditions occurs. With that said, you can always contact the town and negotiate those terms and present an agreed order on how you would want to do that to me. But under the terms of the order, it wouldn't be in compliance until the property is the buildings are either demolished or repaired.
And demolished, meaning physically demolished, or the obtaining of the demolition permit is adequate at the time?
I would not regard the obtaining of the permit, because notice how the original order was written. There was a permit to be obtained and then the work to be done. So it can't be in compliance, because think about how the rest of the town would see it, right? Obtaining
Fair
the
enough.
permit itself doesn't fix whatever's going on that property unless it's executed, right?
Would we be able to allocate a period of time after obtaining the demolition permit, unless it's differently managed by the town or the commission?
Then that's sort of a post hoc kind of thing. So
Okay.
at this point, what I would do is I would assess the fine from the day of non-compliance.
Okay.
And then once you're in compliance, you can petition the town to have a hearing for reduction of fine to address the fine. And assuming that you brought into compliance, I can't speak for what the town will choose to oppose or to negotiate with that, but it is often true with municipalities that compliance is the chief goal. And once you're in compliance, they often do work with you. I can't commit to the town what they will or will not do with such a petition.
I appreciate that, and I appreciate Attorney Nazzaro's willingness to get us in front of the commission at the next available hearing so that we could have this discussion with them. And I appreciate the town working with us in good faith to try to resolve this.
Let me just ask that the town I didn't represent anything that was inconsistent with how this town does business, right?
No, sir, that's correct. And I think that we would be able to resolve a lot of these issues regarding any potential fine. They're actually required to be reduced, I want to say, by the town commission once there's a lien on the property for anything less than full face value. So because this is all intertwined with what the commission will see, I think that's an appropriate avenue. Just to confirm the date of non-compliance based on the record evidence which has been provided to yourself and the respondent is September 15th. So that's the first day of there being a violation. So again, we have August 31st, which is the permit issued based on Mr. Dunham's testimony. Your order required 14 days for compliance, which would have been September 14th. September 15th would be day one of non-compliance. So for the purposes of your order, I would ask that be.
All right, for the record, I'm going to make the following findings of fact and law. I find notice is sufficient. I find the property continues to be in violation of the listed code section. I order a fine of $200 a day beginning on September 15th and continuing until the property comes into compliance.
All right, thank you, sir.
Is there any other business before us?
Enforcement case 2302. Good morning again, Your Honor. Trey Nazzaro. This is case 2302 regarding the violations at 2900 Avenue Au Soleil. This notice was provided to the property owner. Just to go through the file real quick, I'm sorry, we have a statement of violation notice of hearing, setting the hearing for October 4th at 9:30. We have a September 1st notice of violation that was provided to 1013 Lucerne Avenue, which is the property appraiser's address, and also to the property owner Bob and Shaw at Coquina Road in Ocean Ridge. After that, we have a notice regarding notices of the hearing. All notices required by this section shall be provided to the alleged violator by certified mail, return receipt requested. The next photo, we have the attempts at both Coquina Road, which is requested by the property owner, and the property appraisers, and the address on the deed and the property appraisers Address.
One
at-
of these is to the address on the property appraiser's records.
Yes, sir. That is
Okay.
the 1013 Lucerne Avenue. And then the Coquina Road and Ocean Ridge is at the request of the property owner. So there's next a warranty deed showing 2900 Avenue Au Soleil. Address is 1013 Lucerne Avenue.
Do you have any contact with the property owner?
He was the gentleman that was just here, and he acknowledged that through testimony previously that he's aware of additional violations at the property.
Is there a reason he left?
I believe it's because his attorney stipulated to the violations in exchange for the town to agree that you withhold a time for compliance until after the October 13th commission meeting. So essentially that, I think his thoughts are that this is going to be worked out subsequently.
Fair enough. So what's the violation here?
So there's also, I'm sorry, just to go through the record.
Yeah, I know. I
20
jumped the gun on my
No,
questions during
I
your presentation.
apologize.
It's relatively unusual for the respondent to walk out during there.
I handed him the file for this case as well. So he has it.
Tell me what's going on.
We have an email from the property owner indicating his Coquina Road address. He acknowledged receipt of the violations in an email to the town manager and myself Wednesday, September 13th. Sorry, just going through the record. He was emailed because of the returned certified mailings himself, his attorney L. Zacharidis, and his contractor John Crew, which was at the original hearing. A copy of code enforcement notice of violation and set of pardon me, notice of violation, statement of violation and notice of hearing, setting today's hearing. All right. So my apologies. We're now through all the notice because I wasn't sure if a representative was going to be here. The violations are.
That's a good practice, always to get the notice on the record.
Especially when you have multiple addresses and, it gets a little convoluted.
You'll get no complaint from me about doing that.
Okay. All right. Yes, sir. All right. So the violations are of section 2231. There are 3 different violations that were noticed. The first one is a building or other structure which is in such a dilapidated condition that it is unfit for human habitation. The second violation is a seawall or bulkhead which falls into a state of disrepair or ruin so as to allow erosion to land adjacent thereto. And the third and final violation as part of this hearing is makeshift hurricane protection devices such as plywood or similar material which remain in place except for 14 days prior to storm landfall or 14 days following storm passage. So I'll ask Mr. Dunham who has been sworn, to turn to the photographs on the next page. So Mr. Dunham, this is a photograph of the seawall that was taken during your on-site visit. Can you tell me about how that relates to a seawall or bulkhead which falls into a state of disrepair or ruin so as to allow erosion to land adjacent thereto?
Yes, I think there's 3 different pictures which represent 3 different sections of the seawall where erosion has occurred.
Yeah, no kidding.
And I mean, it's kind of hard to tell how deep those are. I think they're about 3 to 4 feet. I mean, that's significant erosion. And you can also see some metal.
I'm not a building expert, but that does not look good.
Oh, it's not. My concern, quite frankly, is that it will maybe kind of continue to the neighbor, because we didn't actually show how close this was to the neighbor's seawall also.
All right, Mr. Dunham, and the next one is an offense report from Sergeant O'Donnell. Can you, and this is,
Sure.
Do you mind reading the highlighted portion on the 3rd page?
Sure.
Or you can, if you want, you can just read the
I'll
entire
just-
narrative, please.
Yeah. So I had a police sergeant that was just doing extra patrol. And during the course of his patrol, he observed 2 issues of concern at Bob and Shaw's or this house. One was an extensive amount of water to the lower interior of the first floor.
So based on that, and given your awareness of the condition of the roof and significant water intrusion, do you believe that that is a violation of the code relative to section 2231-9, a building or structure which is in such a dilapidated condition that is unfit for human habitation?
Yes.
Okay, if we can just move on to the last picture, that is a picture depicting the condition of the roof in its current state. Again, are you aware of any repairs that have been conducted to the roof that would make it watertight after Sergeant O'Donnell's offense report dated April of 2022?
No, sir, I'm not aware of any repairs. I go over to that area regularly to look at the new construction that is right by this house, and almost every other day look.
The neighbors must be thrilled.
Oh, the reason I go over there every day is because I do get a lot of calls about it.
And then finally, Mr. Dunham, you can see there are a number of windows boarded up. Is that a violation of the provision regarding plywood or other makeshift hurricane protection devices?
Yes, sir.
Are you aware of any hurricane or other storm that's made landfall within the last 14 days?
No, sir.
All right, thank you. Do you have anything to add relative to any of those violations?
No, sir.
All right, and then I just, Mr. Magistrate, we did want to go ahead and build a record of the violations that you could rule on independently, but I just want to let you know that I've been in communication with the property owner's attorney. So I sent her the following email in part last night that has been made a part of the record. After further inspection of the property at the request of the property owner, Greg, the town manager who just testified, saw significant erosion behind the seawall. So we noticed, see attached CE 2302, which is the notice that's in the record. The property for that violation, quote, a seawall or bulkhead which falls in a state of disrepair or ruin so as to allow erosion to land adjacent thereto, unquote, as well as the boarded up windows, quote, makeshift hurricane protection devices such as plywood or similar material which remains in place except for 14 days prior to storm landfall and 14 days following storm passage, unquote, and the condition of the inside of the home being unfit for human habitation given the significant water intrusion from the failing roof, quote, any building or other structure which is in such a dilapidated condition that it is unfit for human habitation or kept in such an unsanitary condition that is a menace to the health of the people residing in the vicinity thereof or presents a more than ordinary dangerous fire hazard in the vicinity where it is located. These additional violations are set for hearing tomorrow. This is an email exchange from last night because that's how things work and get things done the night before. Those additional violations are also set for hearing tomorrow to determine whether these violations exist. I ask that you stipulate to the existence of those additional violations, stipulate that the roofs in question regarding 2301 are still in violation, and in turn, the town will ask that a date of compliance for 2302, which is the case that we're working on now, be determined after the October 13th Town Commission meeting so that the parties are able to discuss what a reasonable time for compliance is given the different avenues for compliance, repair, or demolish. So that is consistent with the testimony in the previous case from Mr. Shaw that we're unsure whether or not they're going to repair or replace. And her email to me at 5:08 p.m. Tuesday, October 13th, which is provided as part of the record, is with regard to the requested stipulation, we agree. Thank you for working with us to resolve this to the benefit of all parties. So we do have a stipulation that they exist, but we also would like you to find independently that they do exist. As far as time for compliance, the town understands that there is a demolition permit that is being pursued that would fix some of the violations. Now, the seawall
yeah,
is still an issue that's out there. Not to get into the weeds necessarily, but to replace the water main that's in the property is the intercoastal waterway connection to the barrier island. So it actually goes to the seawall. So if they are going to redo a lot of that water line as part of this process, they may be doing work on the seawall as well. So if there's a new owner or this is going to happen and move forward, I believe that there will be a seawall project as part of that water line.
It would almost have to be.
Right.
Mm.
So, I think that will get worked out as part of the agreement, and then we can work with the parties and the town commission to get some direction at the next Friday, October 13th meeting as far as a date for compliance. So from the town's perspective, we're asking that you make a finding as to those 3 violations, and that we hold, we respectfully request more of your time the week of October 16th, or as soon as the magistrate is available for a follow-up hearing to determine a reasonable date for compliance with the code regarding those violations.
All right, so let me, so you're seeking a finding of violation, which we can certainly do since you've testified to it, and it's pretty clearly a violation. So no compliance date, or you want to just do a status hearing?
So yeah, we would like a status hearing to determine a compliance date at a subsequent hearing.
Do you want to do that now?
Yes, sir, if we could, and we can include that in the order, and we can make sure to provide that to the property owner and his
When are you
attorney.
looking? When do you want to do it? Certainly after the meeting on the 13th.
Yes, sir.
You guys have town council meetings on a Friday?
Second Friday of the month, 9 o'clock sharp.
That's the only town I know that meets on a Friday. Wow. All right, that's a totally unnecessary observation on my part. So you want to do it probably not that week after. You looking to November, or do you want to do it late October?
If we could do it sometime in October, I don't know what.
Let me hold on. What are we on Wednesday? Wednesday seemed to work pretty well, right? How about the 25th? Does that work?
Yes, sir. I think that we will have a significant amount of information by that time.
Do you like,
Could we? Could you do you have availability the 18th? I think that I mean, that is
hold on, let
cutting
me
it
look.
close.
No, you got West Palm.
Okay.
Any other, we don't have to do it on Wednesday.
We don't.
19th or 20th.
Can't do the 19th. I could do the 20th.
Okay, great.
9:30?
Yeah. All right, so for the record, in case 2302, I'm going to make the following findings of fact and law. I find notice is sufficient. I found the property in violation of the 3 listed code sections. I adopt by reference the testimony of the city manager as to the nature of those violations. And I set this for status hearing October 20th at 9:30 a.m. And I withhold on fine at this time.
Thank you, Mr. Magistrate.